Oyez, oyez, oyez. Anyone having business before the King's Justice in the Superior Court of Justice, attend now and you shall be heard. Long live the King. Long live Justice Hennessy presiding.
Good morning, all.
Good morning.
Professor.
Good morning.
Let me say as we start, I hope that these are very unprecedented times health-wise, and I hope that everyone and their families are doing well.
Good morning, Your Honor.
Good morning.
Good morning, Professor Messamore.
Good morning.
When we left off yesterday, I had indicated that the next area of questions I had for you were with respect to the debt allowance increases or the debt ceilings that had been established. Do you recall that?
Yes, I do.
And then what I'd like to do is to turn to your report, conclusion area, I think, page 256, please.
Okay.
I'm in Exhibit 78.
Thank you. Thank you.
Okay. And Professor Messamore, this is an area in your report. I trust you'll agree with me. You're talking about the debt allowances and how debts were continually added. Is that right?
Yes, that's right.
Okay. And I'd like to begin with the second paragraph that begins the fact that, do you see that?
Yes, I do.
Bless you. Now, I understand it's your position, your conclusion, that if Ontario's position that award number 15 ended the matters for Ontario and Quebec, indeed, for any future liability for increased annuities, that would be tantamount, in your opinion, to an increase of the debt ceiling. Is that correct?
Yes, I think that's fair to say.
That's a fair assessment of what you've said?
Yeah.
Okay.
Yeah, it would have been a concession to a single province that would have been immediately seized upon by the other provinces, since the principle throughout had been equity and equal treatment. I might say, just kind of to finish a thought on something that was under discussion yesterday. I agreed, Ms. Barclay, with you that, you know, when I was making the case about the discussion of the Dominion provincial arbitrators dealing with increases up to $4, and my position was that, reading that material in historical context, it seemed clear to me that the discussion only ever, well, I shouldn't say only ever, mostly was concerned with up to $4, although the treaty in full was read out, of course, and you mentioned the comment by Burbidge at the in his ruling that said any increase beyond that would have been a matter of grace, and I agreed with you that referred to the clause about such further sum Her Majesty may be graciously pleased to order. And I, of course, I mentioned that phrase twice in my report. And I think, as I recall, the position I wanted to make in quoting that exactly was that I saw that almost as a reinforcement of the idea that amounts above $4 were not under consideration at that time. And I guess, you know, I would leave it to legal specialists to parse the language. I think reading in historical context, the fact that Justice Burbidge used the past tense, he said, any increase beyond that would have been a matter of grace, not will be a matter of grace. I just wanted to make that clear, just to finish the thought of the point that we were making before. But yes, I come back to the, I guess, the two central points that I hope my reports made clear. One being that I consider the discussion that took place to be entirely around limits up to $4, and the other being that the principle was maintained throughout all these years that there had to be equity in treatment with from province to province. That meant sometimes adjustment according to individual circumstances, material circumstances, you know, for example, whether a province had their own crown lands, this sort of thing. But this is why I kind of use the phrase highly improbable, that there just simply would not have been a kind of incidental provision that would have grossly increased the Dominion's liability with respect to a single province. So that's the thing I wanted to make clear.
So thank you for that. If we can go to your report. And I'd like to read from page 256, the paragraph that begins the fact.
Yes.
It's your opinion that the fact that the debt allowances were limited and specific, not subject to ad hoc adjustment, is important to bear in mind, as it implies that it would be highly improbable that the Dominion government would ever agree to any transaction that would have the effect of increasing the debt allowance for any one province.
Yes.
For the Dominion to assume responsibility for increased debt in the form of an obligation for payments under the Robinson treaties without a requirement on the part of the province to pay interest on that sum would be tantamount to unilaterally increasing the debt allowance for a single province. So that's what I think you were referring to a moment ago.
Yes, it is. Yeah.
Okay.
Yeah.
And just on a point of clarification, of course, if, and understand, I think it's clear from our position in this case that Ontario does not accept that Award 15 is tantamount to increasing the debt allowance, but it would not be for a single province, would it? The UPC had a debt allowance. Ontario and Quebec did not singularly have a debt allowance, did they?
No, there was a debt allowance that was articulated in terms of the province of Canada with a percentage allocated to each province.
Well, a percentage of excess
Of
debt.
excess debt, of course, yes.
So the debt allowance of
Yes.
62.5 originally increased to 73,
Yes,
increased again to allow for the 84 retroactiveness.
right.
It's not a single province, it's the provinces of Ontario and Quebec.
Okay, yes.
And that's significant, of course, because award number 15 released Ontario and Quebec. You remember that language, right?
Okay, yes.
So that's fine. Okay, so I wanted to talk to you about the debt increases or the debt, I'll be very clear. Not the debt increase because excess debt changed, as you've said,
Yes,
but
yeah.
the ceiling, the allowance.
okay.
So when Galt and the Fathers of Confederation were sorting this out, you said that they were precise numbers based on about $25 a head. Is that correct?
Well, that sounds contradictory to say precise based on about $25. I guess what I meant to convey in this discussion was that they tried to find a formula that would work on a per capita basis to assume an equal per capita amount for each province. Yeah.
And that was $25 a head.
Yes. Well, okay, not exactly. It was a set dollar amount, put it that way. The set dollar amount was roughly, as we've heard, based on $25 a head. But of course, we know that Nova Scotia later complained, wait a minute, for us, that doesn't actually work out to exactly $25. And New Brunswick got $27 plus, this sort of thing. So I think, as I believe I said in my earlier testimony, it's more helpful to think of this in terms of a set dollar amount.
Okay. So, and of course, to your point a moment ago, you raised in your testimony that the money matters for these debt allowances, they were addressed equally. I believe that's what you said.
Addressed equally.
When they changed, they were addressed
Oh,
for
I-
all the provinces at the same time.
I understand. Yes, that with subsequent increases. So for example, I said in 1873, the increase was 16.81% across the board.
And that's when the UPCs, of course, the province of Canada's was increased by approximately 10.5 million.
Yes, that's right. Yeah. And then the interest adjustment in 1884, there were other adjustments my report gets into. I think the final one that I deal with in 1907 for an adjustment not in the debt allowance. It specifically said in that legislation that nothing would affect the, maybe I should just consult the language here.
What are you referring to?
Sorry, in 1907 legislation to change the financial subsidies in Confederation. That would be, let me just find it
You're
in my
speaking of
report.
this, you're speaking of the
Um,
subsidies now, not the debt allowance?
That's correct. Yeah, 253 is on my report. I said that the subsidies were adjusted, the grants, annual grants, and also the per capita subsidy.
Okay.
And based on population scale, more or less. And then I said, with reference to that, the 1907 amendment left the question of the provincial debt accounts untouched, and the federal government would, quote, and this is in the legislation, have the same power of deducting sums charged against a province on account of the interest on public debt in the case of the grant payable under this act to the provinces as they have in the case of the existing debt. And in this instance, I only cited the legislation itself, but at the time, I went back into Boos to see how did he understand this? Am I reading this correctly? That the debt allowance was untouched, and that was his language, that it was untouched. Boos's dissertation was written, I believe, in 1928, and so he took his study up to include a 1926 Royal Commission. It was called the Royal Commission on Maritime Claims, which sounds like something to do with shipping losses, but in fact was to do with claims of the maritime provinces to the fact that they didn't think the debt allowance was fair. And we see this constant recurrence to language about this is going to be a final settlement and things like that, which comes up again and again. But
wanna focus
yeah, I'm sorry, I
on-
don't mean to digress.
I want to focus on the debt allowance.
Yes,
and
of
talking
course.
about some of the subsidies.
Yeah.
And I want to focus on the time period that's most relevant to this case and not what happens in the early 1900s.
Okay,
So you told us, of course, that the Act of 1873 increased the debt allowance uniformly by 16.81%.
yes,
And then you've also told us that under political pressure, Sir John A. Macdonald, the Prime Minister, made that retroactive by an Act of 1884.
that's correct.
And the retroactiveness of that act had the effect of paying back to the provinces any interest that they had paid when their debt allowance was lower. Isn't that right?
When it was lower, is that what you said?
That's right.
Yes, that was my understanding. Yeah, yeah.
Okay. So that was just a recap of
Yeah.
what we had discussed yesterday.
Yeah.
Okay. And then you say that the 16.81% was done to ensure the important principle of equity. Is that right?
Yes, that although in 1873, the concern was that Quebec and Ontario were indebted in excess of the debt allowance. It wasn't possible to do anything for Quebec and Ontario without doing something equal for the other provinces.
That's right. And that, of course, in 1873, when that Act of 1873 applies, that's the first increase for Ontario and Quebec.
Yes,
and the first for New Brunswick,
Yes,
but it's the second for Nova Scotia, wasn't it?
that's correct.
And if we could turn to slide 128. Your slides, Professor Messamore. Nova Scotia was one of the colonies, of course, that entered Confederation,
Yes,
and it received a debt allowance by the British North America Act in 1867.
yes.
And then you
$8
say
million.
here,
Sorry, $8 million, yes.
yes, $8
Yeah.
million, thank you. And then you say here, retroactive to 1 July 1867, Nova Scotia received an additional annual subsidy of $82,698 for 10 years, and an increased debt allowance from $8 million to $9,186,756. Do you see that?
Yes, I do.
And you don't give a year for that, but that happened in 1869?
Yes,
And you agree with me that no other province received a debt allowance increase in 1869?
that's correct. Yeah, that the complaint was based on, again, on equity, that Nova Scotia's Joseph Howe complained that because the debt allowances were rounded figures, that Nova Scotia hadn't in fact gotten $25, that they had actually got less. And so that was why it became necessary to make the adjustment for equity. Yeah.
And that was a negotiation between Nova Scotia and the federal government, isn't that right?
Yes, I think so.
And it's true too that Joseph Howe, he was the premier.
Yes, he was.
He wasn't particularly happy with the fact that Nova Scotia had joined Confederation at all, isn't that right?
That was right.
And he had spent some time complaining about the financial deal that had been entered into, isn't that right?
Yes, he had. Yeah, I think he said that all Nova Scotia got was the price of each Nova Scotian got the price of a sheepskin, I think was his language. Yeah.
Okay, so they, by my math, and doesn't need to be too fine a point put on it, but that was about a 15% increase. So they received that when nobody else did.
Well, I would question that. I think that they received what everyone else did was kind of the
Oh,
point.
no, hang on. In 1867, upon Confederation, they, like all of the other uniting provinces, received a debt allowance under the British North America Act. You've agreed with me on that.
Yes,
And then in 1869, Nova Scotia alone received an increase. You've agreed with me on that.
correct.
Thank you. In 1873, PEI was joining Confederation, isn't that right?
Yes, that's right.
And in your report, you note in 1873 that the MacDonald administration was having some political troubles. Was that fair to say?
That's an understatement. Yes.
It was an interesting read. Our friend Sir John A. Macdonald was embroiled in some political scandals, isn't that right?
Yes, the Pacific scandal had come to light. Their victory in the previous election was very narrow. George Etienne Cartier was desperately ill and would die that spring. And that Cartier was sort of understood to be, well, basically MacDonald's lieutenant in Quebec. There were a number of political challenges. And of course, yeah, this was the time at which PEI entered Confederation.
And that increase in 1873, it was by an act in May 1873.
Yes,
And MacDonald's government had actually fell in November that year, didn't it?
it did.
He had to resign over that political scandal.
Yes.
So I'm going to suggest to you that an equally plausible explanation for increasing everybody's debt allowance in 1873 was a political motivation.
Yeah, I think I've suggested that. Yes. When you say equally plausible, what's the other?
Well, the idea that they had to do it to be fair to everybody, that might have been part of it, but certainly a minority government embroiled in scandal, as you've said. Your report suggests that he squeaked into power by a margin of 6 votes.
Mhm.
That politicians make decisions to stay in power.
Yeah, so I think it's not a contradiction in terms to say that it was a political decision to increase the debt allowance and it was equally granted.
Okay.
Yeah.
And you've suggested, in fact, that money was extended by the ruling party at different times for political reasons. Do you recall discussing in your report Quebec receiving a rather substantial federal grant of $2.5 million in 1884?
Yeah, I do suggest that at times there were political motivations behind all of these things.
Okay.
And I think in each case, there had to be some principle at work. So for example, if we say the case of PEI that we've already referred to, being given a per capita substantially larger debt allowance. And the case could be made on a number of grounds. And one of them was, for example, that they would receive no benefit from the expensive railway projects, these kinds of things. So yes, they were political decisions. And there was always a search for a principle, I suppose, that could justify that.
In fact, about Quebec, you said that this grant, I believe it was for railways. Do you recall that?
Can you
We can turn
direct
to your
me
report.
in the report
It's
to
page 128 of your
yeah,
report.
just to get the particulars here. Yes, yes. And so what I say about that, again, thinking of the rationale in each case, this was granted on the theory that the railway between Quebec and Ottawa was part of the transcontinental network, which had been similarly supported by federal subsidies. So again, that in that case would be the rationale that goes beyond the merely political.
Right. And at the
Sorry, I
highlighted,
just missed that. 128.
at the bottom of
Bottom of
128, Your Honor, of Professor Messamore's report.
Thank you. Thank you.
If we could go back to that page, actually, thank you. Thank you. At the bottom of 128, this was just the reference that I was suggesting to you, that political motivations often create financial decisions. And you say Quebec received a federal grant of 2.5 million in railway subsidies in 1884, a measure that may have been meant to buy the continued support of Quebec MPs for the Conservative administration.
That's correct.
And of course, the Conservative administration, MacDonald, while he had to resign in 1873, I understand he was reelected
Yes,
in
and
1878.
that's correct. Yeah.
The
And so
public's
the-
memory is always short.
Absolutely, yeah. And I would suggest economic downturn and other things were the main factor in his reelection. And well, maybe short memories, but what's the expression? It's the economy stupid. Was that the electoral phrase that was used at one point in the US? But yeah, I think with reference to this particular quotation, I think again, to provide context, we should go to the next page that explains the theory under which this was granted. So yeah, so what it says is this was granted on the theory that the railway between Quebec and Ottawa was part of the transcontinental network, which had been similarly supported by federal subsidies. The railway grant caused bitterness in Ontario, as these things inevitably did.
I see that. Thank you. Turning to Manitoba. Manitoba joined Confederation in 1870.
That's correct.
You say in your report that it also received an initial debt allowance.
Yes, maybe it would be helpful if I go to the part of my report that deals with Manitoba's entry into Confederation.
We can certainly do that. I have it slide 133 where you set out. We can also, of course, go to your report.
Yes, so page
It's
76.
like it's your
according
report
to the slide.
76. The point I was going to take you to was when they joined through the Manitoba Act in 1870, the debt allowance that they received, you say at the bottom of slide 133, was equal to $27.77. Isn't that right?
Yes, so this was immediately on the heels of that discussion with Nova Scotia that I think it was important that they, at this point, decided we better not round it off. We better be precise. And so the debt allowance was $472,090. So if, you know, they didn't say $500,000, they said, because we're dealing with a comparatively small population.
That's right. It looks like
yeah.
a small amount compared to everybody else, but that it was still based on a per capita amount.
That's
generally.
correct.
Could you tell me that or explain that more fully? They didn't base it on
Um,
a precise amount. They looked at the per capita. Is that
No,
what
what
they're
I,
saying?
I'm sorry, Your Honor, what I meant to say is that because Manitoba's entry into Confederation came immediately after the negotiations with Nova Scotia, where Nova Scotia's debt allowance that had originally been set at 8 million was increased so that the per capita would be $27.77 based on the Confederation levels of population. We ended up with a figure that wasn't a rounded one, like 8 million. I can't remember precisely what it was, but it was essentially a way to retroactively grant equity to Nova Scotia because Joseph Howe had complained that rounding had worked to their disadvantage at the time of Confederation. So my point with respect to Manitoba was simply that having learned from that experience, they didn't round the amount of Manitoba's debt allowance, but granted a debt allowance of $472,090.
But that was based on
On
a
on-
precise per capita.
It
amount.
was based on $27.77 per capita, yes.
Thank you.
And perhaps it would be fair, because we're talking about a lot of different numbers, it would be helpful if we looked at some of the slides in Professor Messamore's deck.
Okay.
If you turn to slide 127. This is one of the slides you talked about on Monday. Everybody there?
127.
Yes, please.
Thank you.
And Professor Messamore, just so we can keep the numbers in our head perhaps a little easier, you say here, you're talking about, I think it's fair to say, would you agree with me in the last point there? These are the numbers at Confederation, is that true?
Yes,
So you say that the province of Canada, of course, Quebec and Ontario, had initially, we all agree that it went up, but initially been allowed 62.5 million or $24.92 per head.
yes,
New Brunswick had been allowed 7 million or $27.77 per head.
yes,
Nova Scotia had been allowed 8 million, which was $24.17 per head.
yes.
And then if we turn to slide 129. And that's 129, this is 128, please. So now we've, in 1869, Nova Scotia's debt allowance is singularly increased, and they're now equal to New Brunswick, 27 766 rounded up, 2777.
Yes,
And then you've just told us that when Manitoba in 1870 joined Confederation, theirs was also 2777.
that's correct.
Okay, thank you. Does that help with all of the numbers?
Thank you.
Okay. So let's find this spot. Oh, yes. So in 1885, Manitoba's debt allowance was increased. Isn't that right?
Can you direct me to the place in the report?
I certainly can. It's page 132.
Yeah, so what I see here is that because Manitoba at the time of Confederation had a population that was very small, 17,000 was the count. The amount the debt allowance would yield was very small. And so because Manitoba's population was growing rapidly, the decision was taken to adjust it. Although I think the point was that that the figures still remained comparatively small in terms of what it would yield.
Well, in fact, it yielded now, again, on a per capita basis, $32.44 per capita. Isn't that right?
Yes, that's right.
Okay. And no other province's debt allowance was raised to $32.44 in 1885?
Sorry, in 1885? No.
And-
So again, this meant to reflect different material circumstances and the recognition that some calculation had to be made for this. I suppose the thinking is that it was a small population, a small sum of money. But yes, I think a response to particular circumstances where there could be rationale for it.
So I'm not sure I actually had an answer to my question. Perhaps I did. But my question was, no other province's debt allowance was raised in 1885, was it?
So they were raised in 1884.
Manitoba's was also raised in
yes.
1884, wasn't it?
Yes, it was.
And
Yeah.
then it was raised in 1885.
What's our date here? Is it 1885? I can, yes, that's right. Yeah.
And nobody else's was raised after 1884.
Right.
Thank you. Speaking of the considerations that you suggested, at the bottom of this page, you have a paragraph that says various considerations helped to shape the context in which these improved terms were offered.
Yes.
And you talk about Manitoba's provincial boundaries were extended in the same year as the 1882 subsidy increase, and MacDonald encouraged Premier, is it Norquay,
That's right.
to take a strong stance against Ontario's Oliver Mowat in the matter. That was the issue of the Ontario-Manitoba boundary,
That's correct.
promising him, quote, all the support that I can give you.
Yes.
So again, here's another suggestion that there's a political motivation to changing original financial arrangements. Isn't that right?
Yes, I think that's a fair inference, that there was a political motivation and a financial rationale.
Okay. Mr. Messamore, thank you for your time. Your Honor, I believe that is all the questions I have for Professor Messamore.
Thank you very much.
Yeah, I'll give you a minute. Before I, oh, sorry.
Just trying to overcome some technical. Go ahead.
Before I ask any questions of the witness, there's just a housekeeping matter that I need to address. The court is aware from case conferences that have happened, and I think from discussions that have taken place before the court, in particular in respect of Exhibit 75, which was the Six Nations accounts, that there was some concern about relevant documents not being before the court that could be or should be before the court. And to make a long story short, I was able to get a number of documents from Canada yesterday that corresponded to a report that Mr. Angel refers to in his perspective report. So I thank Canada for that. Unfortunately, the other documents involving the Six Nations, no one has been able to provide me with those documents, but you might recall that I think it was Mr. Lipton for Ontario advised, well, you could go to the archives and do it yourself or get it yourself, or that's available to you. And we've done that.
I think it was a vote of confidence in you.
Yes, indeed. So we've gone to the archives, we've got the documents, and we've organized them. And what I would like to do is, first of all, because I think they're new documents that people haven't seen, and that I wanted to get them to my friends as soon as possible. And I just wanted to have them entered as exhibits. And I have an idea on how to, there's basically three packages. One is a package of documents that come from Joan Holmes' report. The second is excerpts of the Department of Indian Affairs General Accounts 1846 to 1979 T-1460 from the National Archives. And that includes in Exhibit 75. But this time, instead of coming from an internet source, it's right from the National Archives. And then there is just a separate one-pager that comes from RG 10 volume 623. And so my thought was that I would have these entered as numbered exhibits, and that if my friends want to challenge the authenticity or admissibility of the documents, because you might recall that Mr. Marcello, when we first saw Exhibit 75, indicated he was reserving his right to challenge the document in some way, but he wasn't specific on how he might challenge it. And we have an agreement as to admissibility and authenticity in this case. And basically the rule under that agreement is, look at, if archival documents can go in, if you're going to challenge them, you have an obligation to let people know you're going to challenge them. And so what I wanted to do is I want to get all these documents to my friends. And if they want to challenge them, to let me know. And if we have to then make a motion to bring the archivist to prove them, we'll do that. I don't think that's, I hope it's not going to be necessary. So I guess at this point, I would just turn to my friends, and with my assurance that these came from the National Archives, is there any objection to them being marked as exhibits? And I'd like to do that.
May I address the court without a robe? I did not think I would. I did not think I would have to today.
Go ahead.
I just want to read these documents. We'll come up with our position. We'll let my friend know. I don't want them marked until we've reviewed them. They're not in the JBD. They're not being put in through any particular witness. They arrived on our desk here this morning. They have to be considered in conjunction with Exhibit 75. We just want a couple of days to look through them and discuss them as a team. Some of us are here, some of us are elsewhere.
Or a
That's all.
day.
A day. Meanwhile, if he wants to put a letter to these as a collective, I don't care if they're marked collectively with a letter for now.
I was just, what I was
Thank
going
you.
to ask, are you considering putting these documents to this witness?
No, I don't think I need to put them to this witness, and
So
it's
there's
a
no
matter
need
of
to mark
immediate
them.
notice.
Right, so there's no need to mark them as a lettered exhibit now. Take a day, Mr. Marcella, we have all kinds of fancy technology that people can look at things. quickly.
Thanks. Thank you for letting me address the court.
All right, thank you. And Ms. Evans, you're up.
I hadn't had a chance to speak with either of my friends about this, but I was also going to take the position that we've only entered as exhibits documents that we agreed to in the joint book of documents because they were attached to expert reports. So, but we're not just entering any productions as exhibits. So I think that's something we're going to need to talk about, think about, and discuss the proper way to introduce.
And you can take the day, you're content with that.
Certainly, we can talk about it at the lunch break.
Very good. Thank you.
All right, so we'll put that aside and we'll talk at the lunch break. And with that, I can turn to Dr. Messamore and indicate that I only have a few questions
All right.
for you. I wonder if I can ask you some questions about the 15th award of 1899 to 1900. Is that about the time?
Yes, that's right. Yeah, the process.
And that was a negotiated award?
Yes, it was.
And was the subject of discussions not of that leading up to that award? There was discussions not only of the annuities issue, but there were other issues such as the Common School Fund.
I didn't delve too much into other issues. My focus was on this, but I mean, this is part of a larger discussion, and other issues were discussed.
Would you agree with me that, I guess in today's parlance, we'd call it horse trading? There were lots of issues that the federal government, the Dominion, and the Ontario were discussing, one of which was the annuities issue.
I think that's a fair assessment.
Can we go to slide 208 of your compendium? Not of your compendium, excuse me. Slide 208 of your demonstratives. Slide 208 is where you have a response from Mr. Newcomb to Van Conant's letter of June 19th, 1893, inquiring about increases to the annuity above that,
$4.
above, let me finish the question. Above that, based on $4 per person, correct?
Correct.
And Newcomb says, the point to which you refer to will not be lost sight of. Questionable, he continues, though it is very questionable whether the provision in these treaties to which you refer, and that's the Robinson treaties, the two treaties, the Huron and the Superior, correct?
Yes,
Can be made the basis of any legal claim against the province of Canada. That's what he says.
that's what he says.
So my question is, are you able to help the court in identifying whether there was any detailed debate or argument or discussion during the arbitration about the issues of whether there was a legal claim against the province of Canada?
With respect to annuities above $4
Yes.
per person, my position throughout has been that the discussion focused on payments to $4 and that there were only ever incidental references to any amount above that.
I don't recall in the historical record seeing any debate or discussion about legal as opposed to equitable claims of future amounts greater than, based on future augmentations greater than $4 per person. Did you?
Within this Dominion provincial arbitration?
Correct.
That's my understanding,
That you didn't see
that I
anything.
did not see that. No.
And you didn't see any discussion or debate about about whether there might be a legal or equitable claim, not against the province of Canada, but against the Ontario as opposed to Canada?
Again, I would not describe this as a debate happening around that issue in any context of amounts over $4 per
Okay,
person.
so maybe I should rephrase it then. The discussion going on to which Minister of Justice Newcomb was referring to, he's referring to the, and I called it a debate or discussion, but it's the adjustment of the debts of the province of Canada, right? Or how, what we,
Oh, I see, legal claim in that sense, something that might culminate in an adjustment to the debt of the province. Is that your point?
right, because the
Yeah.
arbitrations were about the province of Canada. It wasn't about the debts of Canada.
Right, yes, correct, yes. So, I'm sorry, the question then is, was there consideration of how amounts or detailed consideration or debates about how amounts over $4 per person might have affected the debt of the province of Canada? Is that the question?
No,
I'm
the
sorry.
question is included in the discussion at the arbitrations or the debates, discussions, arguments, and even decisions.
Yes,
There wasn't any discussion, debate, argument about whether Canada might be liable under the treaty or Ontario might be liable under the treaty. It was about adjusting debts for the province of Canada, if I'm making myself clear.
And just to muddy that, when you use the word Canada, do you mean the Dominion?
Yes, I'm sorry, I meant the Dominion Canada. Thank you.
okay, I think if I understand your question properly, I can agree that there was no such debate.
Well, I want to make sure that you understand, like,
Right,
like,
no,
like,
no debate about,
like what, explain how you understood my question, which is obviously inarticulately, very inarticulate.
Uh,
Or do you
Okay.
want me to try again?
Yeah, perhaps that would be best.
Okay. So what was going on in the arbitrations was Ontario and Canada were trying to figure out what the debt of the province of Canada was.
Yes, yes.
They were not engaged in a discussion, debate, or argument about what how and if Canada might be directly Canada, the Dominion, might be directly liable to the First Nations.
Correct.
Nor were they involved in discussions, debates, or concerns about whether Ontario might have direct liability to the First Nations.
Correct.
It was about adjusting accounts as between the two governments, the Dominion and Ontario.
Yes, yes.
I think I got there, and I
Okay.
apologize for being inarticulate.
And I should just note, and
Oh,
Ah,
yes, I'm sorry.
yes.
Yes, I,
And we should add Quebec in that. And,
Yeah.
and speaking of Quebec, at the end of the day, are you aware what happened, whether the Dominion has pursued Quebec for its share
in this, in this.
in the as a
subsequent-
result of the arbitrations?
I'm afraid I can't answer that. I don't know.
So your question, it was about adjusting accounts as between the three governments.
That's right. Yes. Can we turn to slide 272? Now, at slide 272 of your demonstratives, you identify some years in which some of the actors in 1899 had identified there were surpluses from which annuities could, augmented annuities could be paid, correct?
Correct.
And those amounts, sorry, those dates, excuse me, were agreed to by the crowns?
By the representatives of each,
Of both the Dominion and Ontario and Quebec.
yes.
And now,
I just need a second to catch up.
Yeah.
Please. Slide 272.
yeah,
Thank you.
now the years that the governments agreed amongst themselves that there had been a surplus, these were agreed to after the Privy Council had ruled in 1896 that Ontario was not liable to Canada under Section 109. Is that correct?
That is correct.
Would you agree with me that a settlement between the crowns after 1896 that minimized the monies payable to the First Nations was in 1899 in the interests of both the federal and provincial governments?
Yes, I would.
I want to go to slide 119, if I might, where you talk about equity. And I thought in your testimony, you talked about equity being a defining feature, and maybe I'm not paraphrasing it correctly, but how did equity figure into adjusting matters between between the various parties to Confederation?
So here you're not simply referring to the province of Canada, the Section 142 arbitration. You're referring generally to the provinces entering Confederation?
Well, I'm trying to get a sense from you as to what you as a historian can help the court with in terms of this idea of equity of treating partners to Confederation with equity.
Mhm.
And I'm wondering if you could elaborate on that.
Okay. I guess what I've tried to suggest is that there was a process of negotiation at Confederation in the conferences, and part of that included the financial terms. But in order to get the parties to agree to enter Confederation, it was understood that each had to feel they were getting fair treatment. I quoted some observers after the fact who really emphasized this point that it was essential that all parties be treated on an equal basis. And I used the term equity because sometimes material circumstances differed and there had to be a particular adjustment in each case. And so this is in some instances, a matter of looking at the material circumstances of the colony in question or the province in question and deciding what would constitute a fair arrangement.
And when you use the term equity or fair arrangement, you also just in your testimony just now used the word equality.
Okay, yes.
And can you elaborate on what you meant by equality?
I suppose,
Equality among whom?
equality among the provinces, but I think equity is perhaps a better term because that did not always precisely mean equal treatment in every instance because material circumstances differed. And that's why I prefer the term equity, because there was a negotiation based on those slightly differing material circumstances.
So for lawyers, when people use the word equity, their mind jumps to the difference between equitable obligations and legal obligations. And how did you mean the term in a different way, or what did you mean by it?
I certainly didn't mean it in the legal sense. I don't have the expertise to use the term in that way.
Okay.
So I meant it in common parlance that we think sometimes that treatment is meant to ensure a fair result for each party, which may not, because of differing circumstances, mean precisely the same treatment.
And does it have to be equitable in order to seal the deal of confederation? Is that what
Yes, I think
happened?
that's fair to say. Yes, the parties would not have agreed had they thought it was not fair to them.
Thank you. If I could move to page 259 to 260 of your report. This is the part of your report that I wanted to ask some questions about. You remember the other day, I think you raised the issue of the problem with the fox in the hen house.
I did, yes.
And so these questions are about that idea. And at page 259, in the middle of the page, or about 1/3 away down the page, you're referring to Oliver Mowat. And I'm gonna 1, 2, 3, 4, 5, 6, 7, 8 lines down from the top of the page.
Yes.
After you had discussed why it would make sense to have fixed annuities capitalized,
Yes.
you then say, this is not to say that provincial authorities were inherently untrustworthy, only that a party most interested in effecting cost savings might not be able to regard the matter in a disinterested way.
Yes.
And then 4 lines down, you say it might be added that the apparent belief of Ontario Treasurer Alexander Ross that the onus was on the Indigenous annuitants themselves to determine when a claim for increased annuities was warranted suggests that a trust reposed with that government may have been misplaced, given the attitudes then prevailing in the 19th and earliest 20th centuries. And I think, as I read your report, you then eventually come on page 260 to really what was an answer where you reference Chief Justice Strong's 1895 ruling at the bottom of the text on page 260, where Justice Strong notes, the Indians were under the protection of the imperial government, ... Not until 1854 was the management of Indian affairs transferred to the provincial governments. The Indians had therefore the highest security which could be given for the payment of the augmentations, the assurances and covenant of the imperial government. Period. There was therefore, no reason for giving or implying any other.
Can you
It-
tell me, sorry, where you're reading from? On
Yeah, I'm reading
page
from the bottom of
260?
page 260.
Yes,
The last quote, the last paragraph, there's a quote from Chief Justice Strong going over to page 261.
thank you.
And so in effect, I think what you're trying to communicate in this portion of your report is that you're pointing out that the Chief Justice is observing the importance of an independent actor having the ultimate decision-making authority on the subject. Is that fair?
Yes, it is.
Can we turn to,
On the subject of,
oh, sorry, on the subject of an annuity that is not capitalized where a party has where a government has an interest in saving costs, this is the fox in the hen house problem, and it is better to ensure that there is a neutral third party whom has the final decision about what to pay.
I think so.
That was the point.
thank you.
Can we turn to questions about capitalization at slide 303, please?
Okay.
Now, the other day you testified that there was an $8,200 amount that would be capitalized at 4%, and that amounts to $205,000, correct?
Yes, that's correct.
That's just straight math.
Yes,
But just to recall, for everyone to recall, that $8,200 was an annual amount that was calculated in respect of the Huron Treaty, correct?
yes, that's correct.
And it was based on a $4 amount,
Correct.
based on a fixed population at some point in time.
Yes, that's
Do you
correct.
recall what year that was?
I think that my understanding as to population was that it, no, I don't specifically recall the year. I think it is in the report, but I think that the population number, just as the rate of capitalization, was a matter of negotiation.
Yes.
Yeah, so I think, what, 2,650, do I say that here? Or I say that somewhere, I think, but.
Whatever the
Yeah.
population
Yeah.
number is, the $8,200 was arrived at based on a $4 amount and based on a fixed population of Huron annuitants.
That is correct.
Had nothing to do with the superior annuitants.
That's correct.
And the two crowns, the Dominion and Ontario, and I guess Quebec as well, for whatever reason, and I did not take into account that Canada was continuing to pay the $4 augmented annuity to the superior plaintiffs even after 1874.
Yes.
Did you find any discussion as to why Canada decided to pay $4 to the superior plaintiffs in the future?
No, I didn't, because I didn't really consider that part of my small piece of this much larger question.
Mhm. And did you find any discussion in the historical record as to why the Dominions and the two governments, Quebec and Ontario, agreed to a capitalized annuity of 205,000 based on a fixed population of RHT beneficiaries when they knew that population was fluctuating?
Well, I think in a sense it was part of the correspondence leading up to the ultimately the orders in council that would in turn lead up to Award 15. But I would just describe it as a process of negotiation.
It was just a soft and it's what they could agree to.
Yes, I think so.
All right. Now, are you aware of how the 205,000 was recorded in the accounts of the government of Canada?
If I understand your question properly, I think that what I believe, and this is not in my report, but I think that the capitalized amount was divided equally into the accounts of the Huron and the Superior. As I say, this is not in my report, so I don't want to.
I'm going to suggest to you that this split was about 54.5% to the Huron accounts
Okay.
and 45.5% to the Superior accounts. Would that
Okay.
refresh your memory, perhaps?
I'm afraid it doesn't.
Okay.
All I can tell you with any certain or any recollection on my part is that amounts were allocated for each, even though it was understood that according to the belief of certainly Hogg for the Dominion and other parties, that future payments up to $4 for the Superior were not strictly warranted based upon the principle of there being excess.
All right.
Um,
So
I just have to catch up on that. Was
Yeah.
the question to Professor Messamore, is it your understanding that the capitalized amounts were divided, I'm not sure, equally to the accounts of the Hurons and Superiors, or did you say allocated 54-45 to the accounts? And you're saying you don't know? I just sort of missed that.
Yeah, I had asked whether she was aware how it was divided. She said she thought it was divided equally, and I suggested to her that it wasn't quite equal. It was very close.
Yeah.
And the court doesn't have the evidence yet as to the actual date, the actual historical records. I believe they are in the joint book of documents that will
Okay.
identify that that is the correct amount. But the point for this witness is that I'm trying to get at is that indeed, even though it was all with respect to the Hurons,
Yes.
it somehow gets part of it, 45.5%, I would suggest, gets credited to the Superior account.
Yes, that is my recollection. And again, this is just based upon recollection. It's not in my report, but when I said equally, that was, I would accept that was inaccurate, but
Okay.
yeah.
So let's turn to page 305 of your demonstratives.
Oh, right.
And these are, I just wanted to go over the orders in council, and we talked about there being 3 orders in council that were relatively the same.
Yes.
And at page 305, we have Canada's order in council, and it references that the 205,000 is in respect of increased annuities under the said treaties. So the treaties being referred to are both the Robinson and Huron treaties.
Yes, yes. I
In
did
fact, the
infer that,
last
yeah.
sentence of
Mhm. Yes, it does say
of
that.
that
Yes.
slide
yeah.
talks about the
Yes.
Huron and Superior treaties. And similarly, at slide 307, Ontario's order in council again, references the said treaties and the Huron and Superior treaties, and again, references the 205,000.
Yes, it does.
And so it seems to me that somehow the governments in at least 1899, when they're doing their internal, whatever they're doing internally during this period, they're somehow thinking that the excess of, or the monies needed to pay the annuities. Sorry, let me recast that. Would you agree with me that what's happening in 1899 is that the governments are treating the Robinson Superior and Robinson Huron entitlements as somehow linked in some way?
Well, I guess insofar as the capitalized amount, according to the order in council, appears to refer to both amounts, maybe entitlements might not be the question to use.
Yeah, fair
Yeah,
enough.
yeah.
But 45.5% of the monies needed to pay an augmented annuity calculated in respect of the Hurons gets credited to the superiors.
I would have to rely on someone
Whatever the
else's
percentage
knowledge
is.
of that. Yeah, I don't know. I can't speak to the percentage, but I can tell you that, yes, I agree that some of those funds are roughly, well, not equivalent amount, but close to equivalent amount was allocated to the superiors, yes.
And do you have any explanation as to why the crowns, the three crowns did that?
It would be merely speculative on my part. Is that what you're asking for?
Well, I'm asking if you can help the court or me with any
Yeah.
explanation as to why they did it. Is there anything in the historical record or that you as a historian can provide some guidance with as to why that happened?
I didn't investigate that historically. If I were to think about it, I would say that they were already paying $4 per person. It would have been a hard thing to go back and say, well, certainly to go back and say, we're going to try to reclaim some of this money that ought not to have been paid. I don't think that was ever in contemplation. But to suddenly roll back the amount that was being paid would have been a very difficult matter to do, and it would have, I think sometimes the phrase that's used, spread disaffection. There had been, of course, the Northwest Rebellions in 1885. When I think about the correspondence that I've read and between government actors, like say John A. Macdonald and other figures in this era, most of the preoccupation seems to be with respect to Indigenous matters in the West. And I think that also they might have considered treaty terms of subsequent treaties that were being negotiated in the West. And again, with the caveat that I'm not an expert in treaty processes. But I think that a general sense of fairness and wishing to avoid disaffection might be the explanation, purely speculative on my part.
Oh, okay, that's what I was gonna,
Yeah.
Okay, so if it's purely speculative, we'll treat it as such.
Yes.
Perhaps we can go to tab 20 of compendium that the Attorney General of Canada provided to you, and that is a statement of the collections from the Superior Territory that the three governments agreed to.
Yes.
I
Okay.
had a couple questions about that document.
Ooh, all right. It's tiny.
It's tiny.
Yeah.
Okay.
We'll try and bring it up on the computer and blow it up. So the first entry for 1850
Whoops.
is an
Tab-
eight,
Sorry, tab 20.
yeah, tab 20,
Oh, got
page
it.
113 of the compendium is a statement of all collections from the territory surrendered by the Treaty of 1850 west of Batchewana and all expenditures made thereon 1850 to 1892 inclusive.
I'm still looking.
Yeah.
What's it? Does it have an exhibit name?
It's
Got
exhibit
it.
Y.
Got it. Thank you. Got it.
All right, so the first entry for 1850 under total expenditures is an $8,000 amount.
Okay.
And I'm suggesting to you that that $8,000 is the $2,000 initially paid by the government as part of the treaty promise.
Okay,
Are you aware that that's the case?
that would be a logical inference.
Did I say $2,000? Yes, thank you,
Oh,
council.
yeah.
It's 2,000
I
pounds or
understood.
$8,000.
I understood what you meant. I'm sorry.
Well, yeah, but
yeah.
I thank council for the correction.
Mhm.
Best to have that cleared up.
Mhm.
So I don't see in the account any offsetting amounts for any amounts collected prior to 1850 by the Crown. Are you aware whether the Crown collected any monies prior to 1850
Collected any monies?
from the treaty territories?
I think that what I'm aware of, the context of the treaties, and again, this is I would describe it as kind of a superficial understanding
Yeah.
of this process, that there was dispute over mining licenses issued and perhaps some revenue flowing from that. Is that kind of?
Well, I'm
the
just wondering if
question?
you were aware, because I think the record before the court shows that there was monies collected,
Okay.
but I don't see any monies
Oh, I understand. Okay.
identified here
I see.
on the collection side.
Okay, yes. Yeah.
And I was wondering if you might had any,
Yeah.
could help the court with that at all.
Only in the broadest sense of the
Okay.
word that I understand that mining licenses have been issued, and that was, I think, something that Lord Elgin took issue with and said that
Okay.
that should not have been done.
And also, if you look at 1851 on the, I guess, the fifth last column under the heading payments to Indians.
Which column would that be if you
The-
count,
the-
if you
it's-
counted from the left?
Counting from the left, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th. 13th column. There's for 1850, there's the $8,000 amount. And then for 1851, and for every year thereafter, there's a $2,000 amount.
Yes,
And are you aware that that's the pound 500 or 2,000 fixed annuity portion?
that's my understanding, yes.
Now, did you see in the arbitration debates any discussion about whether the pound 500 should be deducted as an expense?
I'm sorry, I don't quite understand your question.
Well, in this calculation of whether or not there was ever any surplus
Oh,
or not, from
Okay.
which an augmented annuity could be paid,
okay.
do you recall any discussion or debate as to whether the $2,000 annual amount should be deducted?
I'm afraid I don't recall.
Do you recall whether there was any discussion or debate between the crowns as to whether the $8,000 should be deducted?
I don't recall.
Could I
Can
just
we
have a
go
moment?
over?
Could I just have a moment to catch up?
Yes.
Thank you.
Dr. Messamore, can we just go over to tab 21, page 115 of your compendium?
Tab 21.
Yes.
Um,
Of exhibit
Compendium or
Y,
slides?
not of the slides, of exhibit Y.
Oh,
the
exhibit Y.
compendium, yes.
Okay.
And what I wanted to do is I just wanted to make sure that we all understand what is going on with this calculation. It's entitled a tentative statement of the periods when Ontario and Quebec become conjointly liable to pay increased Indian annuities by the Lake Superior Treaty. And I take it your counsel has probably done the highlighting here, or did you do the highlighting?
I did not do the highlighting.
Okay, you've seen this document before.
I have.
Part of your report. Is it?
It is certainly part of what I used in preparing my report.
Right. And so here under in the third column, first column is the year, and the third column is the progressive excess of expenditures over collections.
Yes.
So this is a running total of the calculations from tab 20, correct?
That is correct.
And so when we start off in 1850, in effect, the First Nations are starting off $8,000 in the hole, so to speak.
Okay, so to speak, yeah, that it shows that expenditure for that
Yeah.
$8,000.
Right. And so when the person who prepared this table, when they identify that in the second column, the amount of collections in excess of progressive expenditures at periods when the Indians can be paid without incurring loss, the reason why they have a positive amount of $3,680.62 in 1853 is because although there might have been from tab 20 a very large net collection amount, it had to overcome the negative amounts in the years previous, correct?
Yeah, because expenditure was progressive, yes.
Right. So what is happening is that the crowns, at least in this calculation, are taking into account the negative years, right?
Yes, I think that's fair to say.
And what this calculation also tells us is that they're doing their adjustment on an annual basis.
Yes.
And it shows also that the Robinson Superior Treaty Anishinaabe, at least in these calculations, are being credited with 100% of the excess of revenues over expenses, correct?
Yes, I think because it didn't reach the level of $4. Yes, that is.
Right, but when
true, yeah.
in terms of figuring out whether an augmentation should be paid, what the governments are doing is they're giving credit for 100% of the excess of revenues over expenses in their calculation. It's not immediately apparent from looking at the data,
Yeah, I'm sorry.
which is why I tried to take you through.
Yeah,
Okay, maybe, so maybe I can put it to you this way. If you, let's go back to tab 20.
you must.
And you'll see that the total collections in 1853 are $22,638.
Okay.
Are you agreeing because you can read that?
Oh.
Do you agree with that? That's
Yes, I
Okay.
can, yes,
okay.
yeah.
And the total expenditures on the next column look to be $4,141 and some odd cents.
Yes,
Only. Right. And when you net those out, there's a positive number of approximately $17,000 or $18,000 or thereabouts.
okay, yes,
So I'm gonna have 22K approximately
Yeah,
against,
against 4K
Four.
of expenses approximately.
all right. And you say,
And I say that if you go over now to tab 21. When you take that positive approximate $17,000, you first have to offset what the Crown says is $11,000.
I see. I understand your point. Yes,
Right. So my point is that in their calculation, would you agree with me now that what the Crowns have done is given credit to the Anishinaabe, to the First Nations, for 100% of what they say is the excess of revenues or over expenses in their calculation of entitlement?
yes, I would. Yeah,
Yeah, thank you.
after deducting the 8, or the
After deducting
the
expenses.
cumulative,
Yes, I understand that there's a request for a break and I apologize for not realizing it.
okay. We'll take the break then.
Yeah.
All right. We'll recess for 15 minutes.
We're all right.
Ms. Coral, now assume you may be seated.
Professor Messamore, just a couple more questions.
sure.
Um, There were earlier parts of this trial, phases 1 and 2. I don't know if you were aware of that.
Well, I'm aware that there were earlier phases. I don't
Yeah,
have much
and-
detailed knowledge of the nature of them.
Thank you.
Yeah,
I'm just going to put it to you that part of the judgment that was entered in this case in phase 1 and phase 2 requires the Crown to periodically engage in a process in consultation with the First Nation treaty parties to determine the amount of net Crown resource-based revenues. I'm just telling you that that's what the court order says.
yes,
Would you agree with me that your review of the historical record doesn't identify that the Crown did engage in any such process?
I think that's a fair assessment. Yes.
Those are my only questions. Those are my only questions. And it wasn't intended as a mic drop. Thank you very much.
Thank you.
I think there's some other people that might have a few questions for you.
Okay.
Thank you.
Good morning, Professor Messamore.
Good morning.
My name is Spencer Bass. I'm one of the counsel for one of the plaintiff First Nation groups.
I understand.
And I only have a few questions for you this morning. It shouldn't take too long.
Okay.
And actually, the part that I wanted to ask you questions about, it wasn't something that you discussed much in your testimony so far, but it was something that was in your report. And that's the expense items or expenditure items in calculating the years for which augmented annuities could be provided. And would you agree with me that it's fair to say that in the late 19th century, when the various Crown actors were considering whether the augmentation clause had been satisfied in particular years, they were debating or considering whether certain expense items should be included in the calculations?
Yes, that's true.
And one example that I wanted to discuss is at pages 103 and 104 of your expert report. So it might help if we had that in front of us.
Yes. Okay.
And at this section of your report, you discuss a letter in 1881 from Mr. Dawson. Is that correct?
Yes, that's right.
And are you able to remind us who Mr. Dawson was?
He was a member of parliament for Algoma.
Okay. And the Algoma district at that point, it covered the RHT and the RST territories?
I believe so.
And he wrote a letter to the Governor General in 1881.
Yes, I mean, I guess it's strictly speaking addressed to the Secretary of the Governor General, but with the idea that it be conveyed to the Governor General, yes.
Okay, fair enough. And part of this letter was to argue or advocate on behalf of the payment of arrears of annuities.
Yes, I think so.
And if we go on to page 104 of the report, still discussing this letter, I don't need to go into every aspect of the letter, but in one part of the letter, he discusses some Crown expenses. And would you agree that it was his position that in calculating whether arrears should be due, that the government should not include the cost of surveys for mining tracts?
Yes, I recall that detail. Is it in this section? I'm just trying to find it.
I'm looking about the middle of
Oh, yes.
page 104.
I'm sorry. Yes, yes, this is the part at which Dawson raises that issue. Yes.
And his argument was that the Crown Lands Department required parties to have the surveys conducted at their own expense.
That's correct.
And so that's why he said that the surveys wouldn't cost the government.
Yes.
And so according to Dawson, these were expenses of private mining companies, not the Crown, so they shouldn't be deducted in the calculation of whether augmented annuities were payable.
Correct.
And so jumping forward in time a number of years, when we get to the Dominion provincial arbitration in the 1890s, the arbitrators also considered various expense items. Is that true?
Yes, they did.
And they didn't simply accept all of the expense categories that were listed in the statements prepared by Mr. Irving for Ontario?
Yes, these were submitted subject to review by the parties.
Okay. And my question was, the arbitrators didn't just say, okay, you've listed all of these expenses. Yep, these are all expenses. They were questioning various expense items.
Correct.
And specifically in the oral submissions from the parties, the arbitrators questioned counsel about individual expense items.
Yes, that's right.
And perhaps it would be helpful. I'm referring to pages 171 and 172 of your report. So if it would help you, we can certainly turn up those pages.
Yes.
And so one such expense item that the arbitrators questioned counsel about was expenses for roads and railways.
Yes.
And I believe you note that the arbitrators, I think it was Justice Burbidge in particular, he expressed the view that if the roads and railways were built to connect the territories with the rest of the country and not for local purposes, they shouldn't be deducted as expenses.
That seems to be his view, yes.
Okay. And another expense item that the arbitrators questioned about, I think specifically Chancellor Boyd and Justice Burbidge, was that they, I think you have it, they expressed surprise that Ontario had included the cost of paying the annuities themselves as an included expense. Is that right?
That's correct.
And Justice Burbidge expressed the view that the Crown had contracted to provide the annuities at a convenient place. It was their responsibility to get the funds there and to get the funds to the annuitants, correct?
Yes, that's a good summation.
And that the annuitants themselves should not have to bear the cost of the Crown bringing their money to them.
Yes.
But in the statements that were submitted, Ontario had included this as an expense item that they were deducting against revenues.
I'm afraid I can't recall that detail. Do I provide that in the report? I know that there was an itemized list, and that it was a process of negotiation. What ended up on the list, I can't at this moment recall, but
Well, at perhaps we can do it this way. At page 171 of your report,
yes,
you write that, and I'm looking at the kind of the paragraph that starts after the second indented quotation on the page. Starts with, you say, Chancellor Boyd and Justice Burbidge expressed surprise at other expenses that Irving, representing Ontario, considered eligible to be deducted. And then you go on to discuss this issue of the expense of paying the annuities. Is
yes,
that correct?
that's correct. Yeah.
So I took it from that line that Irving, representing Ontario, had considered this expense item as eligible to be deducted.
Oh, I'm sorry, I misunderstood your question. I thought you were asking me if ultimately it had been deducted. Oh, yes, yes, so Irving did consider it eligible.
Okay.
Yes.
Yeah, my question was simply that, in a sense, Ontario had submitted it
Yes.
to be included for
Yes,
deduction,
correct.
not whether, in
Yes.
fact, it was accepted.
Yes.
Okay. Thank you very much. Yeah, certainly. And stepping back for a second and to clarify, these discussions or debates around which expense items to include that we've just discussed, these were occurring amongst various different representatives of the Crown. Would you agree with that?
Yes,
And the Anishinaabe beneficiaries weren't participating in these discussions.
that's correct.
As far as you're aware, they weren't invited to participate in these discussions.
I have no knowledge of that, but there's no evidence to suggest that they were.
Thank you very much, Professor Messamore. Those are my questions for you.
Thank you.
Thank you.
Professor Messamore, I have a very brief re-examination just to address a couple of issues that just came up in your cross-examination.
Okay,
So the first is with respect to evidence that you gave about, well, you were questioned in your cross-examination about your comments that in the submissions before the Dominion provincial arbitrators, you said there was no discussion of annuity increases beyond $4. And my friend pointed you to some examples in the record where, in fact, the further sum part of the treaty was mentioned.
yes,
And you said it may have been mentioned, but there was
and I'm totally paraphrasing, no real discussion beyond
Yes,
$4 per person. Do you remember that testimony?
yes, I do.
Yeah.
Yeah.
Was there any discussion of annuity increases in the form of a share of net resource revenues in
No.
these discussions before the arbitrators?
No,
So was there any evidence that the concept of a share of resource revenues was considered in the capitalization for these annuities?
no.
Thank you. And my next question has to do with a document that my friend put before you. It's in volume 2 of Ontario's compendium, which was marked as exhibit Z2. And it's at tab 28. Ontario's compendium? That's right, Ontario's compendium. So Z2? Volume 2, Z2, tab 28. And this is a transcript from the arbitration dating June 2, 1990. Do you have that before you?
Yes, I do.
And I understand that this specific, possibly 1890. Oh, I'm sorry. What did I say? Sorry. No, 1900. 1900. What did I say?
Okay.
So this particular transcript from this particular date of June 2, 1900, I don't believe you specifically dealt with this in your report, so I believe it may be somewhat new to you. Is that right?
Well, I would have read the entire transcript, but of course, with 500 pages, I had to be selected.
Right, but it wasn't dealt with in your report.
Yes, fair enough.
Okay, so I want to take you to page 359 of this compendium. And I'm going to read this passage. So the chancellor is saying, then the final disposition by award of the Canada account, they're talking about the province of Canada account, that's another item. And Mr. Hogg says, yes, my lord, under the several awards made by your lordships and the references to the accountants, the parties have now prepared for final disposition and confirmation the Canada account containing all the items which have been in dispute between the several governments and which have been referred by the Act of 1891 and by the reference in this matter for disposition and award to this tribunal.
Your Honor,
Yes.
if I may interject. This report or this transcript may not be in Professor Messamore's report, but I do find the reference that she's being taken to now in the compendium of my friend. I don't believe that this is proper redirect. She could have taken her to her in her direct.
Okay, and you say it's in Ms. Evans' compendium, but
It is, in fact, the very page is at tab 33, page 186 of the compendium. My friend chose not to put this to her witness in direct examination, Your Honor.
Sorry, can you give me that tab, please?
Of course, the last tab of Canada's compendium, tab 33, Exhibit Y, and my friend is reading from page 186.
Okay, well, let's hear what the question is first. Thank you. So I'll just finish reading the quote. And Mr. Hogg says, he's being asked, is there going to be any other evidence submitted? And Mr. Hogg says, no other item prior to the 31st December 92. That's 1892. Of course, it may be in making the award upon this account that your lordships would reserve or put in some clause in the award reserving any items which might arise after the 31st December 92, but which may have taken its origin under some statute or arrangement prior to that time or prior to Confederation. He goes on to give an example. And your question is? My question was going to be, what, in your view, does this tell us about Hogg's expectation
about what would happen if there were new debts arising after 1892, but having origin under some arrangement prior to 1892.
And this is something that is new on, I'm just bringing back Ms. Barclay's objection. This is something new to you from cross-examination.
And in fact, Your Honor, where my friend had placed the context or the content of this particular item that she's now for the first time taking to this witness, it's in the portions of the slides which we've all agreed will be removed from the demonstrative. I heard my friend say that she was not intending to ask this witness questions about Award 16. This is getting into that. She said that she would cross-examine Gwyneth Jones about that. This is entirely new. These questions could have been placed to her. She chose not to.
So I put the question to you.
No, I can see that I did decide for the sake of trying to brush through so that my friend could have her over 2 days of time for cross-examination that she requested. I did push through and decide this is something I can deal with Professor or with Ms. Jones. But now that this transcript was actually brought before the witness and she was asked about it in her cross-examination, I thought, I think it's appropriate to finish up on this point.
So you say it was brought out in cross?
I believe it was brought out, just not this passage, but this transcript that's now at tab 28 of my friend's compendium was addressed in cross-examination.
And Your Honor, I'm merely pointing out that it's also in my friend's compendium and she could and ought to have asked the questions on direct examination about it that she's now posing to Professor Messamore.
Well, if you're saying they have left something that is unclear, that was brought out in cross-examination, and there was, let's say, horse trading about what happened in Chief, I'm not seeing the harm of it. If you're telling me that it's a big waste of time, it's we have many miles to go before we sleep. So, go ahead.
So my question again, then to reiterate, is what, in your view, does this passage here tell us? You may take time to read it again. What does it tell us about Hogg's expectation about what would happen if there were new debts arising after 1892, but having origin under some arrangement prior to 1892? Would the Dominion be able to claim against the provinces of Ontario and Quebec for those?
Okay, what I understand this to mean, and I suppose in a sense, when I think about the preparation of my report and the fact that I decided to end it at Award 15 in terms of the arbitration, is that I considered that nothing in Award 16 surprised me, if I can put it that way. It seemed a confirmation of what I felt I'd already said. And I thought it appeared clear to me that the arbitration was dealing with events up to the 31st of December, 1892, as they were then known. But it didn't necessarily contemplate what might happen for new amounts brought forward.
Professor Messamore, I'm not
I'm
asking
sorry.
you about Award 16.
Oh, no, okay,
No.
fair enough. All right,
I'm just asking you about this passage in
Okay.
this transcript.
okay.
I'm just asking about this passage, what Mr. Hogg is saying to the arbitrators on the 2nd of June. And what, in your view, does it tell us about Hogg's expectation?
If I can just clarify which passage in
It's
particular?
on
the
page
one that-
359,
359, okay,
and it's the second time Mr. Hogg is speaking.
yes,
No
Okay.
other item,
yes,
if you want to just read
yes.
that.
No other item prior to the 31st December 92. I'm sorry, that was an answer to Casalt's question. There's no evidence to be submitted. After Hogg said no other item, he says, of course, it may be in making the award upon this account that your lordship would reserve or put in some clause in the award reserving any item which might arise after the 31st December 92, but which may be taken its origin under some statute or arrangement prior to that time or prior to Confederation.
And it's actually
So-
which may have taken its origin.
I'm sorry, may have taken its origin. I'm sorry, did I misspeak there? So yes, I take it to mean that Hogg is understanding that this agreement does not cover any new items that might come to light in terms of obligations. Is that your question? That it is only what has come to light as of the date of the arbitration and items that are known about.
Thank you. Those are all the questions I have in redirect.
Okay. Professor Messamore, I believe there are no further questions.
Okay, thank you.
This comes to the point that we have in this trial where I want to express on behalf of everyone here and from the court our deep appreciation for the effort that you have made, the expertise that you have brought to this trial. We are all grateful for the efforts and the at times inconvenience that this has or that you have had imposed on him. And we appreciate it very much. And we particularly appreciate, I do, the respect that you have shown this process. Thank you very much.
Thank you. It's been my pleasure to do it.
Good morning, Your Honor.
Good morning. Just give me one moment to catch up, please.
Yes, sure.
Okay.
Your Honor, Ontario's next witness is Dr. Kenneth Coates. He's going to be our first witness on Crown allocation. But before calling him, I would like to address the court on the exhibits.
Yes, I saw at the break that things that were sent. I'll just move.
Yes, these were sent electronically during the break, Your Honor.
Thank you. Just one second. Go ahead, sir.
Your Honor, you should have before you 5 documents. And the first document, Your Honor, is the agreement on the expert qualifications and admissibility of the report of Dr. Coates. Your Honor, indeed, there has been an agreement between the parties on Dr. Coates' qualification. And if Your Honor looks at the document at page 2, so Dr. Coates will be qualified as a historian. So I'm looking at paragraph 1A.
Yes.
As a historian with expertise in Canadian history and public policy. And at paragraph 1B, as a result of the above areas of expertise, the parties agree that Dr. Coates is qualified to give opinions on, first, Canadian political and constitutional history. Second, the broader political aspects of the Confederation process as these relate the Robinson Superior Treaty of 1850, including how the financial obligations of the Crown in that treaty were recorded by the Crowns and the historical context of Indigenous Crown treaties, including the Robinson Superior Treaty as it relates to Confederation. Third, the pre-Confederation negotiations between the different Crown actors. Fourth, the reasons behind the Canadian Confederation and the evolution of the Dominion of Canada during the Confederation era. Fifth, the financial arrangements between the Dominion of Canada and the provinces at the time of Confederation, and the implementation of those arrangements. Sixth, the federal-provincial relations of the Confederation. Seventh, the post-Confederation political disputes between the provinces and the Dominion of Canada. And last, the post-Confederation arbitrations between Ontario and Quebec and the Dominion of Canada to settle excess debt under sections 142 and 112 of the British North America Act 1867 and the matters arising therefrom. Your Honor, I will ask that the agreement be marked as the next numbered exhibit.
That's exhibit 82.
So, Your Honor, looking at exhibit 2082 at page 2, second paragraph, Your Honor will see that it's mentioned that as a result of the above areas of expertise, the parties agree that Dr. Coates is qualified to give opinions within his area of expertise set out in the following report, and same is admissible into evidence. And this report is the Confederation, Robinson Treaty Annuities, and Federal Provincial Relations, December 31st, 2021. So, Your Honor, the second document that you should have before you is the report of Dr. Kenneth Coates. And I will ask that this be marked as the next numbered exhibit, exhibit 83, right?
Correct.
And is there any change in what is there any change between what you have brought up and what I received earlier?
So yes, this is the third document, and that's the errata sheet, Your Honor. Should have that before you.
Yes. Is there any change in this document that you?
No, that's the same document.
Very good. Thank you. You can take.
So the third document that you should have before you, Your Honor, is the errata sheet to Dr. Coates' report. And as you will see in the errata sheet at page 2, it corrects 2 typing errors in the report of Dr. Coates. So what should be, in fact, award number 10 was incorrectly typed in as award number 11. And that is in 2 places at page 66 of his report. So at page 66 of his report, second paragraph, line 2, the word award 11,
Yes,
are you there, Yona? Should be replaced with award 10.
award 10,
Yes.
thank you.
And secondly, at the same page,
Yes,
same paragraph, paragraph 2, at line 7, sorry, the word award 11 should be replaced with award 10. At line 7. Got it?
no. Thank you, I have it. Award 10 as well.
Yeah.
Thank you.
So I would ask that this errata sheet be marked as the next numbered exhibit. So moving on, the fourth document you should have before you, Your Honor, is the trial demonstratives. So as per the practice, I'll ask for this to be marked for the moment as the next lettered exhibit.
We're at the end of our alphabet. So what's our plan?
So the plan was to add a number at the end of the last alphabet, which was Z. I think it should be Z3.
What
Yeah,
about
sorry.
AA?
AA.
AA. I'm fine with that. For the 18.
I think we've got another 26 to go if we double the letters. That gives us a lot of scope.
Right.
All right, exhibit AA will be the next lettered exhibit.
So obviously, Your Honor, our intention is to have this marked as a numbered exhibit, which I shall ask at the end of my examination in chief.
Thank you.
And finally, the last document, which is the fifth document, should have before you is the compendium for the examination of Dr. Coates, which I shall ask to be marked as the next lettered exhibit. AB, right?
No, BB. Is that, does that make it understandable to everyone if we call it BB?
BB.
All right.
So, Your Honor, I now propose to call Dr. Coates.
Right.
Kenneth Stephen Coates, Kenneth, Stephen Coates.
Do you solemnly affirm that the evidence to be given by you to the court touching the matters in question between the parties shall be the truth, the whole truth, and nothing but the truth?
Your Honor, I will now proceed to examine Dr. Coates on his qualifications.
Thank you.
I know Your Honor has expressed a preference for this part of his examination to be more concise. So I will highlight the key parts of his response.
Thank you.
So to begin with, Dr. Coates, do you agree to waive the copyright to your report entitled Confederation, Robinson Treaty Annuities, and Federal Provincial Relations, December 31st, 2021?
I do.
Dr. Coates, I want to start by confirming that you understand that your duty here is to the court
I do.
And you have to be as much assistance as you can to the court.
Understood.
And you have signed a Form 53, which is the acknowledgement of expert's duty. And that's enclosed in your report.
Yes, it is.
So I want to highlight some of your qualifications. Is it correct to say that you're a historian?
Yes,
And is it correct to say that you are specialized in Canadian history and public policy?
correct.
So I see at page 108 of your report, you have included your professional resume.
Correct.
Do you have that in front of you?
Yes, I do.
So this resume was written at the time of your report.
Correct.
Has there been any significant change to this resume since?
No.
So Dr. Coates, can you tell us about your academic route to become a historian?
Yes, I studied history at the University of British Columbia. I graduated with a Bachelor of Arts in History. I then proceeded to the University of Manitoba, where I secured a Master of Arts in History at that institution. I returned to the University of British Columbia and got a PhD in history from UBC in 1984.
So Dr. Coates, I will ask you to go a little bit slow because the reporter is trying to follow up and the judge is also trying to take notes. So we used to say in the old days, try to follow the pen. Right?
Those were the old days.
Very old days, right? I know, no longer used. So what was the topic of your PhD dissertation?
I studied Native newcomer relations in the Yukon Territory.
And can you tell the court what is your current position?
I hold a position of Canada Research Chair in Regional Innovation at Johnson Soyama Graduate School of Public Policy at University of Saskatchewan.
And you are also a university professor, is that correct?
I hold a university professor's position as well, yes.
So can you say for which period to which period you have been a university professor?
I've been a university professor since about 1980 in different institutions.
A faculty member since 1980.
Yes,
Thank you.
So these institutions would include the University of Waterloo,
I was the Dean of Arts and Professor of History at the University of Waterloo, correct?
the University of British Columbia,
Yes, I was there for a short time.
so during this period, were you teaching only Canadian history?
I would teach primarily Canadian history. There's subfields within that. And I taught Native newcomer, the history of Native newcomer relations. I also taught Canadian political history. And I taught different aspects of comparative history, looking at Indigenous policy in different countries around the world. More recently, since 2012, I've been in a school of public policy. In public policy school, we don't teach history directly. We take historical perspectives on Canadian and international public policy.
So Dr. Coates, I see from your resume that you have won several scholarships, fellowships, and awards. So I want to highlight two of these. First one is at page 109 of your report, which is the CCAB Award for excellence in Aboriginal relations, August 2017. Can you tell us what the CCAB stand for?
CCAB is the Canadian Council for Aboriginal Business.
And can you tell us a bit about this award?
Yes, this is Canada's largest Indigenous-run business organization, and they grant an award every year for a person they think has made a national contribution to the development of improvement of relations with Indigenous communities.
And who are the previous holders of this award?
There's been done on an annual basis. There's been quite a few, but former Prime Minister Paul Martin received this. Current Governor General Mary Simon received it, and the former Commissioner of the Truth and Reconciliation Commission, Murray Sinclair, received it as well.
And what work did you do that led to this recognition?
And so I have been a commentator on Indigenous affairs for many years. I've advised governments, advised Indigenous organizations and Indigenous governments. I've written about this academically as a scholar. I've written articles in the newspaper, on radio and television, and have been a strong supporter in the context of CCAB of Indigenous economic development.
The second award I want to take you to is the one found at page 110 of the report, is that you are also an elected fellow of the Royal Society of Canada since September 2015. Is that correct?
That's correct.
So how does someone become an elected fellow of the Royal Society of Canada?
Typically, one is nominated by one's university to be a member. The Royal Society describes itself as the preeminent association of Canadian academics. You are then reviewed by a panel of previous Royal Society members or current Royal Society members, who then determine if you're eligible for that recognition. So it's a high honor, in my opinion, to receive that award.
And what is your role as member of the Royal Society of Canada?
I've been on the chair for the last 2 years of the selection committee for the social science division of the Royal Society of Canada.
So what's your role in the selection committee?
We receive applications from across the country, some internationally, Canadians who've succeeded elsewhere, and we adjudicate them and select the very hard process, but select the best candidates for inclusion. There's a fixed number of candidates each year.
What is that number?
About 20.
Out of a pool of how many?
It varies year to year, but between 65 and 80.
All right, thank you for that. So are there any other achievements you want to highlight?
There's one that stands out for me. I was invited a number of years ago by the government of Australia to participate in a major Australian national conference on Indigenous treaties and Indigenous rights. They brought together the leading Aboriginal people from Australia who were activists in law, politics, economic affairs. And they brought in selected people from around the world, scholars in the most part, but activists as well. And it was a huge privilege to be invited to go down as one of the Canadian representatives at that conference.
And in which year was that?
And to be honest, I can't remember.
Maybe just find it on a page. That would help me.
Yeah, sorry.
Is it 2016? Distinguished Visiting Professor, Australian National University.
No, unfortunately, that's not it. I'm afraid I can't see it here.
Okay.
Is it 2018?
Yeah, I think I have it listed somewhere else in the resume. My apologies. I should have known that.
All right. So moving on, I see from your resume that you have written a number of academic books on Canadian history. Right, Doctor?
Yes,
And if I can cite a few of these. So one of the books you wrote is titled From Treaty People to Treaty Nation, a roadmap for all Canadians. Is that correct?
that's correct.
And another book you wrote is titled A Global History of Indigenous Peoples, Struggle and Survival.
That's correct.
And the third one is The Forgotten North, A History of Canada's Provincial Norths.
Also correct.
Could you give me the page reference, please, sir?
Yes, Your Honor. So the first one would be at page 111.
Yes,
It's the third item on the academic books section.
thank you.
The second book is at page 112.
Yes,
It's the second item in the academic book section. A global history.
thank you.
And the last one would be at page 112, academic book section. And it's the fourth from the bottom, The Forgotten North. Got it, Your Honor?
Thank you.
Dr. Coates, have you testified in other trials?
Yes, I have. I was an expert witness in the Chilcotin trial in British Columbia.
So, Your Honor, for the record, the reference to the case is Chilcotin Nation and British Columbia, 2007, BCSC 1700.
you.
So, can you tell the court in what areas of expertise you were qualified in the case of Chilcotin?
The Chilcotin case focused on the First Nations argument that they had outstanding Aboriginal title to their traditional territories. So I was asked as an historian to basically document the early encounters with Europeans, and particularly to focus on the efforts made by the Chilcotin people to keep Europeans outside their traditional territories. They worked very hard for almost a century to stop any Europeans from coming into their land.
So your services were retained by whom in that case?
By the Chilcotin First Nation, the lawyers on behalf of Chilcotin First Nation.
Was your evidence accepted by the court in that case?
It was.
Are there any other court matters you testified?
Not testified. I've done reports for different legal proceedings, but they've all been resolved before we got to court.
So before looking at your demonstratives, I'd like to ask you whether you can explain what is Canadian public policy and how it's related to history.
So public policy is the formulation of specific government legislation, policy documents, and programs that are designed to address national and subnational priorities. So a public policy scholar is looking at the ways in which governments seek to address social, economic, cultural, or other sort of challenges within the country. That's a very broad definition of public policy. Some scholars approach this differently. Some take a theoretical perspective. Others sort of look at political science view of how public policy is made. Because of my background in history, I look at these issues historically. And I would use as one obvious example, the development of the Indian Act. So I've talked about and written about the Indian Act in the contemporary period, in the 21st century, but you can't talk about that without going back and looking at where it came from and why it was put in place back in the 1870s.
I'm done with this part of his qualifications. So I'll ask the court for Dr. Coates to be qualified as an expert according to the terms set out in paragraphs 1A and 1B of Exhibit 82. That is the agreement on the expert qualifications of Kenneth Coates and agreement as to the admissibility of his report.
Thank you. And I understand that's on consent. Plaintiffs, Mr. Bass, yes. Kenneth, thank you. Professor Coates is qualified as, according to the consent set out in the paragraphs in Exhibit 82. Thank you very much.
Thank you, Your Honor. So I'll now move to the trial demonstratives. Dr. Coates, do you have the trial demonstratives in front of you?
I do.
Can you confirm to the court who is the author of these trial demonstratives?
I am the author of these.
And are these trial demonstratives consistent with your report, Confederation, Robinson Treaty Annuities, and Federal Provincial Relations dated December 31st, 2021?
Yes.
So, Dr. Coates, let's move to slides 4 and 5 of the trial demonstrative. So at slides 4 and 5, you deal with your instructions. Is that correct?
That's correct.
And in fact, your letter of instructions is included in your report at page 95.
Correct.
So you were asked to answer 4 questions.
That's right.
And slide 4 contains questions 1 and 2. And slide 5 contains questions 3 and 4, right?
Correct.
Can you take us through these questions that you were asked to answer?
Yes. Question 1. What were the motivations for the Confederation deal? And how were these arrangements, the Confederation arrangements, understood by the relevant historical actors of that time? Very contextual question. Question 2. What was the genesis of the financial arrangements reflected in the British North America Act of 1867, relating specifically to pre-Confederation debts and liabilities of the United Province of Canada, and particularly as those are set out in sections 111, 112, and 142 of the British North America Act.
And in the next slide, question 3 and 4.
So question 3, what did the relevant actors of that time intend and understand to be the meaning of sections 11 and 12 of the British North America Act? Particularly a series of sub-questions. How did they define and identify debts and liabilities of the United Province of Canada? Secondly, did they distinguish between debts and liabilities in section 11? Third, did they intend and understand a debt as referenced in section 112 to be different than the debts and liabilities referenced in 111, section 111? Fourth, whether they intended the concepts of debts and liabilities and debts to cover all outstanding financial obligations that have been incurred by the United Province of Canada, including contingent liabilities extending into the future. That's question 3.
And the last question?
Question 4, to what extent were sections 111 and 112, the British North America Act, considered in the course of intergovernmental dealings in the 20th century, especially the Federal Provincial Constitutional Conference of 1950?
And would it be correct to say that your report is a responding report to the report of Dr. Messamore?
Yes.
Can you tell the court what materials you looked at when preparing your report?
So we had the Messamore report, obviously, since I was responding to that. The collected materials for this court case, which are voluminous, the historical track record is extremely extensive and shared widely. There's a secondary material in there, so there's primary documents, speeches, correspondence, records of debates, statements in the media, for example, proceedings of conferences, resolutions, Quebec resolution, and London resolutions, that sort of thing. And then supplementary materials, articles and scholarly articles that relate to these issues at hand.
Thank you. So moving on to slide 7. So at slides 7 and 8, you have described the key political leaders, right? Are they the key political leaders that were involved in the Confederation process?
Yes, there's a short list of the many ones who were involved, yes.
So what is the purpose of including these 2 slides within your demonstratives?
I guess to sort of highlight the fact that historical processes are sort of the intersection of character and circumstance, the intersection of the individuals who are making decisions, who have ideas, who have values, and expectations, and the reality in which they live, the political circumstances, the economic developments that are occurring. So basically, the study of history is a study of putting these pieces together, and so it helps to understand a few of the names, just to provide some context.
I'm just going to ask you, sir, if you would just keep it a bit slower.
All right, my apologies.
I'm about to say to you all the things that all your students have wanted to say over the years. That's how I'm figuring out my role.
Yes, Dr. Coates, very slowly, can you take us through who are these key political leaders?
Yes, I've identified 7 of them just for consideration. So here, Charles Bagot was Governor General of UPC. He played an important role in the definition of Indigenous affairs and the relationships of UPC and the British Crown. Edward Blake, a very active Ontario a politician, the 2nd Premier of Ontario. One of the individuals who sat in both what's called a dual mandate. He actually was in the House of Commons and in the provincial legislature at the same time for a couple of years. George Brown, in many ways, a leader of the Confederation process. Brown was a newspaperman, and he was the leader of what was called the Great Coalition. Great Coalition saw politicians in the UPC put aside their political differences. Some were reformers, some were conservatives, some were arch conservatives, but they kind of agreed that they had one central purpose, so that was Confederation, and they would agree to that. Brown, who was a strong reformer, basically threw his very considerable public weight behind this movement, and used the Globe newspaper. Very important individual. George Etienne Cartier, a reformer from Quebec, a key collaborator with John A. Macdonald. One sees his hand in many aspects of Confederation. He was a member of the Grand Coalition. He was a member of all the Confederation processes. George Etienne Cartier played a major role in negotiating the entry of the Western Canadian provinces and even the building of the Canadian Pacific Railway. So Cartier is a very key individual.
So moving to slide 8, there are other key political leaders.
Yes, I've identified 3 others. Alexander Galt, a very important Canadian business person, very strong advocate for Confederation, and a key leader in the conceptualization of Canada's financial arrangements. The second one, Johnny MacDonald, in some ways needs no introduction, I suspect. Very prominent UPC politician, a central key proponent of the idea of Confederation, and memorialized for all time as the first Prime Minister of Canada. And the third one is Oliver Mowat, another leading politician from the UPC, a member of the colonial legislature, active participant in Confederation. Subsequently, he became the Premier of Ontario for a very long period of time. And he's best known in that role as an advocate for provincial rights, of an opponent of the centralizing nature of Johnny MacDonald and some of the other politicians.
So most of these key political leaders from the UPC, it would seem, right?
Yes, one could have easily added a list of other people from Nova Scotia and New Brunswick, from Prince Edward Island. It was a large and complicated group of people.
So moving on to the next slide, is slide 9. You have included in your demonstratives a timeline of key events. And these go on from slide 9 to slide 11. So why did you provide us with this timeline in your slide?
I provided the timeline in part because it was important for me to take the 4 questions that were asked to me and to put them in sort of some chronological order. So there was a narrative that would actually fit these pieces together. As an historian, one loves to see the flow of history, how one thing relates to another. You can't separate out strands. So a question might take you down this line. Another question seems to be a separate line, but actually they're interwoven. So you put them together. So the timeline is simply to remind ourselves of the key developments in this process.
So looking at slide 9, the first event in your timeline starts in 1841, is that correct?
That's correct, the creation of the United Province of Canadas.
And then?
Robinson Treaties in 1850. The formal delegation of responsibility for Indian Affairs in 1860. This one was where the Colonial Office passed on responsibility to the UPC. They had done some elements of that earlier, but this was the creation of a separate office. We then get into the Confederation processes, 2 main conferences, Charlottetown and Quebec, both in 1864. The last bullet on this one just highlights the fact that after these conferences, there were major public debates. Basically, the politicians promoted the idea of Confederation through 64 and 65, leading to the subsequent meeting.
Then going on slide 10, further key events.
The subsequent meeting being 1866, the London Conference and the London resolutions that came from there. So the next developments on slide 10, Confederation 1867, the division of UPC into Ontario and Quebec. 69, the capitalization of annuities. 1870, the apportionment agreement under section 42,
You mean apportionment of what?
apportionment of debt between Ontario and Quebec as part of the BNA agreement. The next bullet, 1870 to 73, highlights the fact that the process of confederation didn't stop in 1867, that there was an ongoing effort to include British North American colonies as best they could. Manitoba joined in 1870. The Northwest Territories were added. These were the former Hudson's Bay Company territories, also in 1870. British Columbia in 1871, and Prince Edward Island in 1873. The last item on this page, an increase in the debt allowance under section 112 of the British North America Act that increased the debt allowance for UPC from 62.5 million to 73 million.
And on slide, moving on to the next slide, slide 11.
Just a few more. The increase of annuities under the Robinson Treaty in 1875. 1891, the arbitration legislation passed by the Dominion of Canada and the provinces of Ontario and Quebec. In 1895-96, the Annuities Award number 3, we'll talk about later, and the subsequent appeals to the Supreme Court of Canada and the Judicial Committee of the Privy Council. And in 1898, award number 10 in January of that year on debts and liabilities, which was followed by an appeal to the Supreme Court of Canada. And finally, award number 15 of 1900 and the capitalization of the annuities under the Robinson annuities.
All right, thank you. Anything to add on these slides, Professor? Dr.
No, I just hope that they provide a useful sort of frame for the subsequent discussions that we'll be having.
So moving on to the next slide, which is a slide on the
And-
UPC.
Mr. Amaya, what is your plan with respect to the lunch break?
Should we break right now, or can we
Well, I
carry on?
wondered if you had a plan before you started.
The plan is to make a plan right now. So we are 12, we
Yeah.
started at 10, so we can carry on like.
Oh, we
this.
started at 10, right?
We started at 9, sorry.
No. We
9.
started at 9.
Gaslighting.
We lost track of time, Yona. After
I
looking at the
know.
timeline.
All right, I think it's good pace. You get points with good pace. All right, so 12:30. 12:30.
Okay,
Thank you.
thank you, Yona. 12:30. Half an hour.
From now. We're breaking it. The plan is to break at 12:30. Very
Yes.
good. Thank you.
Thank you, Anna. So Dr. Coates, moving on with your slides. So move on to the UPC. You deal with the UPC at slide 13, right?
Right.
So at the first bullet, you say that the UPC was a merger between the Lower Canada and Upper Canada, right?
Correct.
And this is in fact the first event in your timeline.
Yes, it's an important stage in Canada's political and constitutional development. What happened in the period leading up to 1841, the political life of the Upper Canada and Lower Canada had been tumultuous, to say the least. There had been rebellions in the late 1830s. There were many demands for a political reform and many sort of rejections of that same idea. So Lord Durham had produced the Durham Report, which basically said, how do we get out of this mess? how do we get out of this impasse, this political chaos in the two colonies? And Durham recommended putting the colonies back together, creating a single colony, United Province of the Canadas. So why this? Financial challenges, these show up throughout the history of UPC. These are brand new colonies. They're expanding. They're getting large numbers of new immigrants coming in, demands for more infrastructure, the need to build roads and railways, eventually railways to spur economic development. So the merger was designed to sort of address the financial challenges. There was a hope that it would actually result in eventual responsible government. Durham himself was in favor of that. He was a reformer himself and wanted responsible government in the colonies. There were people who sought autonomy from Britain. A long process that's been going on and continues after this. And it's important to sort of remember that one of the underlying issues here in UPC runs right through are the divisions between the English and the French. Lower Canada, now Quebec, largely French speaking, and very much a different political, different legal system, survivals of the conquest from the 1760s. Upper Canada, new immigrants, mostly English speaking, and with very different views of both the present and the future, how the nation or how the region was going to evolve. So they were joined together. The UPC was joined together, and subsequently went through a whole series of major transitions. They eventually secured responsible government, and if I might, responsible government is simply the idea that the executive branch of government takes its lead from the elected branch of government. Before, without responsible government, you have appointed authorities. So the authorities are appointed by the British government, essentially by the Crown, and they operate sometimes with the advice of an elected assembly, but they don't have to follow the elected assembly. They can do what they want, basically. With responsible government, the idea is that the government, the executive has to follow the wish of the elected representatives. This is a major issue, a very major issue in North American politics. And you don't want to go back in too much in the history of this, but it goes back to the American Revolution, where the American colonies demanded a greater say, particularly in taxation, but not exclusively in taxation, that they wanted control of their own future. So what you see happening in the UPC is sort of a desire not to replicate the American experience, because there's a lot of antipathy to the American model, a lot of concern about how far democracy had gone in the United States, but a recognition that the people had to be heard. And the interesting thing that happened in Canada was that, or in upper UPC, is that political participation was actually more substantial in UPC than it was in England. The property qualifications to be an elector, to be a voter in Canada were lower than they were in Britain. Most people, many people could become electors. So they have the right to vote. They want to have some authority. They want to have some impact as it can go along. So the other things that are happening is that the legislature is now in control. They're starting major projects. Initially, they start finishing up some canals, which are important early on. They start building railways. They find themselves in political turmoil. So the UPC was a single legislature, and all the governments were coalitions. And so the initial expectation of Lord Durham was that you would have a majority in Upper Canada of English people, an overwhelming majority of English people in Upper Canada, and a minority of English people in Lower Canada. And the idea was that the English would get together and dominate the French, so that the UPC would be driven by English priorities. And this was one of the main issues of that time. Didn't happen that way.
Sorry, what was the issue? The fear of that?
No, it was well, yeah. It was that was a frustration because it wasn't working out how they thought. So
Okay.
the English thought, we're going to dominate this new province, the United Province of the Canadas. We'll dominate it. But it didn't work out that way because of the coalitions that had to be made. And the coalitions were as much not about English and French, but about reformer and conservative. And so you ended up with a situation where there's a whole combination of many different parties, different variations on reform, radical reform, more moderate reform, conservative and arch conservative on both sides of the divide between Upper Canada, Canada East and Canada West. So the UPC did not work out the way they thought, and it became somewhat paralyzed because you had governments that were falling. They'd have another election and they'd form new coalitions and that government would fall. So it was a lot of political instability as well.
So all these instability led to major transitions between its creation in 1841 till 1867. Is that
Yeah,
correct?
and I'd add some other transitions that I didn't mention. I apologize. You also have mass immigration, not so much into Lower Canada, or Canada East, but into Canada West. And so initially in 1841, Lower Canada had a higher population, and then Upper Canada caught up and went ahead. So the demographic balance is changing, the economic circumstances are changing, the political system is not reacting particularly well. So the UPC, the politicians of the UPC were looking for solutions. And one of the major solutions they came up with was the idea of confederation.
And that's your fourth bullet, right, on that slide?
Yes, and I should mention that confederation is has potentially two elements. We might talk about this a bit later too. Two elements. One is you could have created a federal state out of just the two Canada East and Canada West. You could have just given them their separate identity and have shared interests in a national government of a larger nature. But confederation, there was a subtext here that all British North American colonies should unite. So you have the American colonies have united to the south. The British North American colonies were colonies that had rejected the American model. They didn't want the states' right orientation. They didn't want what they called mobocracy, the sort of the empowerment of the people at a too high of a level. So British North Americans wanted the British tradition. And so people were talking about this for quite some time, about maybe we can get them all together. It's not a natural thing because the colonies had very little to do with each other. To use an obvious one, British Columbia has virtually no connections with Canada East.
Could you go back just a sec?
You bet.
Sir, when you say they rejected the American model, what features were they rejecting? They wanted responsible government,
Yes.
more responsible government,
Yes.
possibly. And but what were they rejecting?
They were rejecting the over empowerment of the population. The American system has a whole bunch of different kind of ways. But for example, when the United States was created, you could not become a state in the United States until the population had ratified. You're joining what's called the Acts of Confederation, Articles of Confederation. So the people got to choose whether they were in the country or not.
Government by referendum.
Yeah, but in a variety of ways, absolutely.
Okay.
And that in turn, well, I said the phrase before, they described it as mobocracy, too much power to the people. The British tradition put a lot more emphasis on social class, a lot more emphasis on tradition. Sort of the elite shall do the leading. There is an irony to all of this in that by this time, a lot of the people in the United Province of the Canadas were actually Americans. So they migrated to the north. And for those folks, the politics weren't all that important. They just were looking for land and a chance to become farmers. But the one thing I would say is it's important not to underestimate the degree to which British North Americans dislike the American model. And I highlight two things just to reinforce this point. Number one, that when the American Revolution broke out, the Americans tried to incorporate British North America. They actually sent armies up into what's now Ontario, Quebec, and the Maritimes. And they expected the local residents would rise up and join them against the British. And instead, the local residents rejected them. Okay. And then the second one was the War of 1812, where British North America had a chance just to sort of throw its lot in with the United States when the war broke out, and they chose to stand with Britain. So they've rejected America twice. And that anti-American theme, we'll pick it up a bit later if that's okay.
All right, thank you.
Thank you, Dr. Coates. So moving on to the next slide. So here you deal with the Robinson Superior Treaty of 1850. And is it correct to say that, and at your first bullet, we see that you say that the Robinson Superior Treaty was entered at a time when the UBC was still in existence, right?
Correct.
So can you elaborate on the bullets you have on this slide?
I will, with the sort of observation that I'll come back to the Superior Treaty later on and put it in the context of Indigenous government relations in Upper Canada in a broader context, subsequently. So in this context, I think it's really important as we go through these processes to underscore how important these relationships in the treaty relationships were to the First Nation. So there is an issue here of the treaties, and we tend to see the treaties as an act of government, or the government signed a treaty and the government requested a treaty. And that's, we sort of see it from one side. A lot of scholarship in recent years has done a very good job of, we've got hand signals now. This is very helpful. I do apologize to my former students too. That the government, we now have a much better understanding of how First Nations people saw the treaty process. And we'll talk about this more later, but just really quickly, remember that these treaties were not in isolation. There had been treaties signed in Southern Ontario well before 1850 in the Robinson Superior Treaty. There had been treaties signed in the Maritimes that actually went back into the 18th century, in the 1750s and 1760s. Those were called peace and friendship treaties. And there were a whole series of treaties signed in the United States. So the Indigenous population knew about treaties. They knew they were there. They knew what other people had negotiated. They knew what they should expect in their relationship with government. And what I wanted to highlight here was simply from the First Nations point of view, that these relationships were with the monarch. We have a little trouble with this in contemporary Canada because we don't see the monarch in the same terms as they would have seen in the 19th century. But this was the leader of the biggest empire in the world. And the monarch was very powerful and symbolically very important. So for First Nations, these treaties were not just agreements, not just contracts. They were kind of sacred pacts between the First Nations and government. And I think what I'm trying to highlight here is that when the Robinson treaties were negotiated by William Robinson, who was there on behalf of the UPC, but that the relationship that was being established was between the Queen of England and the First Nations. And that I just have a quote here from the very beginning where it says in part, William Benjamin Robinson, on the one part, on behalf of Her Majesty the Queen. And that's not just a technical phrase. And if you look at the subsequent history of treaty making and treaty processes, that bond is very deep and very real and very important to First Nations people.
Thank you, Dr. Coates. Any other thing you want to add on this slide?
No, that's it.
So moving on to the next few slides, where
Sir, I'm just going to ask you always to name the number of the slide, identify that for the record, if you don't mind.
yes, sure, Yona. So we are going now on to slide 15.
Thank you.
And from slide 15, to slide 16 and 17, you deal with the motivations for confederation, right?
I do.
So at slide 16, and also in the next slide, 17, you deal with the primary motivations behind the push for the BNA colonies to create a union, right?
I do.
So can you tell us what are these primary motivations?
So I'll outline them in stages. So I'm just going to give you a quick overview of what those main elements were, and then we'll go back and talk about them in individual detail subsequently, to make sure we deal with them in good order. There's a whole range of motivations, and any one list is never going to be complete, because you had so many actors, politicians, colonies, government of Britain, etc. But let me highlight what I think are the first ones. Number one, that Britain was encouraging confederation. This is not an opposition to Britain. It was with the support of Britain. Britain saw that the colonies were costing them money and potentially causing them difficulty with the United States. So Britain thought confederation would help in that regard. Second point, the relationship between Britain and the United Kingdom and the British North America colonies were shifting. So the old order, the 18th century and early 19th century relationship between Britain and British North America was actually shifting quite dramatically. And what had emerged in that process was that the individual colonies had strong local identities. So British North America, if you looked at a map, you could cover all the part that was British North America, and it would look like a contiguous region. You think it would flow one to the other, from Nova Scotia to New Brunswick to Quebec to Upper Canada, Prince Edward Island and Newfoundland a bit off to the side. But the reality was each one of these colonies had developed quite independently. So Nova Scotia's culture and value system society was markedly different than Upper Canada. And I think that process was causing a real change in the relationship with Britain itself. Third point, that the British North America colonies were clearly wanting greater political autonomy. They very much wanted to be more independent from Britain. But secondly, they also wanted to stay within the British Empire. Just repeating something I said before, that they did not see joining the United States, for most people, as the obvious solution. Third, and again, we'll come back in some detail to these later on, there was great fear of American expansionism.
So wait, so we are now on slide 17, right?
Yes, my apologies.
Moving on to slide 17.
Yes.
So you have two bullets of further motivations.
Yep.
So what is the first bullet about?
First one is the fear of American expansionism. A concept used to be very well known in Canada called manifest destiny. The idea that Britain, the United States, had the God-given sort of aspiration and right to control all of North America. This is how the Americans sort of viewed themselves. And the Americans were becoming increasingly active. I'll talk about this later on, but in Red River, which is now Manitoba, and British Columbia in particular, and a reminder that in 1867, the United States purchased Alaska from the Russians, a process that was called Seward's Folly at the time, but turned out to be a very excellent real estate deal. The Russian-American Fur Company had owned and controlled this on behalf of the Russians, and the United States purchased it. And think there's a whole bunch of reasons why people thought this was a very bad idea at the time. But from a British North American point of view, all of a sudden America is on your northwest flank, way up in the far northwest. And it fueled concerns that the Americans were going to fill in the gaps. If you're way up here and you're down in Minnesota and Oregon, clearly you're going to want to push these things together. And so that purchase, which happened after Confederation, was very important.
And on your second bullet on that slide.
So another motivation behind this process was financial. UPC had run up some very substantial debts on public works. I talked before very quickly about the fact they had a growing population. lots of immigrants coming in. The people have to have roads built, you have to have railways built, you have to have bridges built, ports, other facilities. And the government of UPC, like most governments at this time, this is a very common 19th century phenomena, basically got, I wouldn't say greedy is too much, but overzealous. They got convinced that the growth was going to continue, that there'd be many more people coming, that the economy would continue to expand. So they made major investments in public works. And what happens is you end up with a big financial challenge. So UPC found itself in grave financial difficulty. And the UPC leaders were looking for a solution to all of their problems, their financial problems, English-French tensions, conservative reformer tensions as well. So for them, their primary, these are one of the primary motivations for Confederation.
So, Dr. Coates, what is the importance of looking at these motivations?
Well, I think as Canadians and other countries are the same, have a tendency to read history backwards. So the tendency is to look and say, well, we're Canada. So clearly that was a natural thing, that it's just obvious that all the British North America regions would get together. There's nothing rational about this or logical about this from an 1860s point of view. There were some people talking about it, but they were also talking about a union of maritime provinces, we'll discuss later. Newfoundland was very much an independent region that did not see itself having much in common with the other British North American colonies. British Columbia is on the other side of the continent, on the other side of the Rocky Mountains. And to get there from UPC was extremely difficult. It took days, if not weeks, if you went by boat, it took weeks and weeks to get there. So there's nothing obvious that Confederation takes the form that it takes. And you could imagine any one of a dozen different outcomes from the situation we find ourselves in 1860. So you look and think, well, what is it that drove Confederation forward? How does that become sort of a logical outcome? Because it's in one sense, in retrospect, Confederation makes a great deal of sense. It does seem logical.
And you said that these motivations, there could be many motivations, and these ones, the ones you listed at slides 16 and 17 are the primary motivations. But within these primary motivations, are they like the most important ones, you would say?
So if you put 5 historians in the room, you'll come up with 7 different answers to your question, right? So we have different views on different things, and it becomes a bit of a how you see the world sort of unfolding. The primary.
I'm stopping myself from saying that's nothing compared to economists.
Yeah, please don't hold back. Yes, I agree. I think the need to address the instability and fragility of Upper Canada was a really important driver in that process. And among the issues on fragility was the question of finances. So that's sort of, in one sense, sort of number 1 and number 1A. Those two things that are very much folded together. The second one, in my sense, would be the Britain's encouragement. That if Britain was resisting this, they had many, many mechanisms for making sure that the colonies did not go down this path. And they were doing exactly the opposite, finding ways to encourage different aspects of Confederation. And I think those are the 2 most important ones. The American expansionism was of no small consequence, but I want to highlight something, and that is the fact that for many people in British North America, these sort of loftier questions about political loyalties and British ties were not all that significant. So the people who settled in the Maritimes, Nova Scotia and New Brunswick, many of them came from the former American colonies. They were loyalists. They had ties into the United States, and some of them had friendly ties. Upper Canada had a large number of its people were actually migrants who came across from from New York State and moved over into Upper Canada as a northward and northwestward projection of the United States settlement frontier. British Columbia had fairly strong ties in the 1850s in particular to the United States. So there was a fear of expansionism, but a big part of the fear of expansionism was that there were a growing number of Canadians who found it acceptable. So for the political leadership, it was how do you stop this from getting out of control?
Thank you, Dr. Coates. Your Honor, I think now would be a right time to break for recess. That's convenient to Your Honor.
Thank you. And it's 12:30 till 1:45. Does that suit everyone? All right, thank you. That will be our break.
Until 1:15.